أعطيك نائب شو؟ بس منين يكتبون؟ غير البرنامج ممنوع شو؟ Women of
Why 7? So we basically say this is as per merit. This is as per merit. It's not as per the category. So once this safety rests, actually he has come up basically this when was
Sorry, bit late.
Supplementary list. Item number 1, pronouncement of judgment.
So in order to the facts, and I'll just read the operative part. The writ petitioner has made prayers for quashing the impugn office order dated 28/2018, issued respondent number 2, releasing the gratuity amount is set to respondent number 3. Direct is that respondents to recover the amount already drawn by respondent number 3, and also for directions respondent number 3 to return refund the amounts. In this context, it has been noted that in instant proceedings under Article 226 of the Constitution, this court is not sitting in appeal or revision and cannot exercise its powers to grant relief as prayed. However, this court also cannot close its eyes when grievances have been brought before it by the writ petitioner who appears to have come before this court by way of writ petition as last resort. In consideration thereof, is ordered as follows: the succession missed case number so-and-so pending with the court additional judge in council court shall be resumed for disposal in accordance with law. All the facts and materials, including conduct of respondent number 3, shall be taken into consideration when deciding rival claim of the petitioner respondent number 3. Necessary orders after affording adequate opportunity to the parties to adduce evidence shall be passed, including orders for recovery. Otherwise, if it is deemed the amounts released were done so irregularly, it shall be opened to the court additional judge. This council court shall to also make attempts for conciliation by mediation or any other manner of out of court settlement. As ordered above, writ petition accordingly stands closed and disposed of. Right. But the parties are put to notice to appear on 2nd May at 10:30 a.m. in the morning before the court of the. Yes.
But any mention?
May I please, Your Lordship? I beg to mention item number 14, Your Lordship.
Number?
14. Let this matter become after 3 weeks, Your Lordship.
Yes.
Let this matter be taking up after 3 weeks.
After?
3 weeks. It's a joint request.
Why?
Lordship, 2 weeks may be given, Lordship. 2 weeks will be.
What about, you're not asking the petitioner? Joint request from the respondents only?
We have already taken the consent from them.
Joint request means, yes.
Okay, Lordship, no objection.
What's the matter about? Not more matter?
No matters, Your Lordship.
It matters 2 weeks, yes. Yes.
Similar prayer for item number 15, Your Lordship. 3 weeks.
Yes.
Item number 15, 3 weeks, Your Lordship.
Take 4 weeks, yes.
Your Lordship.
May I please, Lordship, I beg to make a mention part 2 of the hearing, this item number 16th.
Yes.
From the counsel for the petitioner. If this matter may come after 2 weeks, Your Lordship.
Why?
I have to obtain some instruction. I'm yet to receive the instruction, Your Lordship.
This matter for 2 weeks to enable the learned government advocate H. Abraham to obtain instructions. Yes.
Hello, bless you.
May I please, Your Lordship, I'd like
Yes.
to mention supplementary item number 6, Your Lordship. Senior counsel is unable to appear.
Number six, which one? Who you're mentioning for?
Petitioner, Your Lordship.
Why it's fixed today, especially?
Your Lordship, senior counsel is unable to take the matter today.
You're there, we will do it. No. After 1 week, yes.
Obliged, Your Lordship.
Please, Your Lordship, I beg to mention item number 11. For respondent number 10, Your Lordship, I kindly pray for time. Conducting counsel is on sanction leave.
Pensionary matter, my lord, I'm praying if it can come up next week.
What's the matter about?
Dispute between the two wives, lordship.
You're appearing for on behalf of Sincons on sanction leave.
Lordship.
Yes, Your Lordship.
Next week, lordship.
Respondent number?
Respondent number 10.
As the counsel respondent on sanction leave, this matter after 1 week, yes.
Obliged, lordship.
Yes. Number 11, that's 11.
11, lordship.
Your Lordship, similar prayer for item number 13.
13, 11, 13. Yes.
Obliged.
Call out this.
May I please, my lord. My lord, I beg to mention item number 12. Prayer matter carrying up to 2 weeks, my lord.
Why?
My lord, the senior counsel is still recovering.
You're not feeling well.
My lord.
Yes, your first respondent number?
5 and 6.
Counsel for 6. Servicing that, sir, as the senior counsel is indisposed. Oh, Mr. C. Summers, as the senior counsel for 156 is indisposed, matter be taken up after 2 weeks.
2 weeks, my lord. My lord.
Prayer aloud, yes.
Supplementary list. Item number 2.
Yes.
Please, Your Lordship, I'm appearing for respondent number 1. Your Lordship, if this matter can be taken up down the list, Your Lordship, my senior is on his way, Your Lordship.
3.
May it please your lordships. My lord, this is a case,
1 second.
my lord, where the reached petitioner is a, my lord, assistant lecturer in Edmonds College, my lord. He is holding a college post. Now, my lord, in Annexure 4, page 32, my lord, if come, the Shillong College, my lord, advertise the post of, at page 32, my lord, Annexure 4. Now, Shillong College, my lord, advertised, my lord, 3 posts of lecturer, my lord, 1 for geology and 2 for commerce stream, your lordships. So that was published in Shillong Times dated 23rd October 2022, my lord. Lordship, I will kindly take my lord to the language. Lecturer, sanction post such and such, commerce 2, candidates having UGC norms. My lord, the problem starts from here.
Yes.
Now, my lord, so far UGC norms is concerned, your lordship, this is normally applicable to central universities and other affiliate universities. Now, Government of India, my lord, Ministry of Human Resources as well as Land, in the year, my lord, 2008, they formulated a scheme which is called UGC scheme, normally applicable to central universities, but they gave an option to the state government that if you desire, you too can apply it. But if you apply, that will be applicable as a composite scheme, and entire UGC regulation will apply. And that the funding pattern will be 80% of the expenditure will come from the central government. So this is the meaning of UGC norms, your lordship. Now, my lord, following this, UGC, my lord, formulated a rules and a regulation in 2010, then 2018. Now, my lord, when this advertisement has been made, the rule which was holding the field was the UGC regulation 2018, my lord. As per 2018, your lordships, my lord, so far, my lord, recruitment of assistant lecturer or professor are concerned, my lordship, they have given the prescribed UGC qualifications. Then there is no age limit, no upper age limit, my lord, for that. They have not prescribed any upper age limit.
In the norms.
In the norms. So that applies. So, my lord, I was under the impression, obviously, my lord, I am teacher, I am fully aware, this is UGC norms. So, my lord, when I applied, I was around 33 years. So, I applied, I was shortlisted. Call for the interview, I appeared for the interview. After that, no communication. In the meantime, I came to know what happened. That instead of me, they have prepared a select list. So far, commerce stream is concerned. Select list, my number appeared at serial number 2. There are 2 posts. One has been appointed. When my turn came, the select list was placed before the governing body. And governing body, my lord, the principal of the college was a ex officio secretary of the governing body. Now the recommendation made by the governing body is not number 2, because number 2 has become overaged. As per the my lord,
Yes.
Meghalaya government's prescribed qualification age limit, 32 is the maximum age limit. So instead of me, my lord, the one who appeared at serial number 2, and she happened to be a, my lord, daughter of the principal. I have made a statement also. Now she has been recommended for appointment. And on this basis, she has been appointed and my case has been ignored. Now, your lordships, it is very clear and categorical, and that has been...
Where are the norms? That there's no age prescribed.
My lord, I'm coming, your lordship. Page... UGC norms? Right.
Isn't
my lord, I'm just coming. Huh? This is 18 to 60. Page 62, your lordship.
Page 62.
My lord. This is the UGC regulation of 2018. The relevant part is at page 64.
Yes.
My lord. Direct recruitment for discipline of arts, commerce, humanities, education, law, etc., my lord. Assistant professor. That is equivalent to lecturer. They have mentioned as lecturer. Lecturer has been designated as assistant professor. Eligibility A, B. These are the, my lord, prescribed qualifications. Master degree such and such. These are the norms, lordship. This. Now, nowhere they have mentioned that requisite qualification, prescribed age limit is this. Nowhere they have mentioned. Now, lordship, doubt may come into your lordship's mind. Since they have not mentioned anything, so it has been left to the state government. No. Because there are other cases where UGC, APS, before many other high courts, that question was asked. Is there any age limit so far the UGC is concerned, your lordship? UGC made a categorical statement. We have not prescribed any age limit.
So
the reason...
It's not even left to the colleges in their own wisdom discretion. It's not...
No. I'll come
to... appoint a person 60 years old.
It can be, your lordship. Before superannuation, yes. Now, another thing, your lordship, the age of superannuation is, as per the UGC norm, 65 years. Yes. Now, I have annexed that. Now, 65 years. So, if you are making an appointment following the UGC norms, then the teacher will continue till 65 years. Now, there were a lot of, my lord, complaints from various state government. They sent letters to MHRD. Then MHRD, after ultimately considering, so far the age of superannuation is concerned, they have exempted. And I have annexed this notification, your lordship. My lord, that is at page 120. Annexure 13. This is addressed to all education secretaries in charge of higher education of the state governments. My lord will come to the relevant part at page 121, paragraph 5. Bearing in mind that the question of enhancement of age of retirement is exclusively within the domain of the policy making of the power of the state government, the issue of age of retirement has been left to the state government to decide at their level. The condition of enhancement of age of superannuation to 65 years, as mentioned in this ministry letter dated such and that, may be treated as withdrawn for the purpose of seeking reimbursement of central government, etc., etc. So this exemption has been given by this letter. There is no such exemption, my lord, for upper age limits. To my knowledge, it have never been neither the state government. Instead, what the state...
Yes.
So, my lord, this needs to... In fact, my lord, this issue has gone to the Supreme Court also. The Supreme Court is very categorically said, once you adopt these schemes, entire thing has to be followed. And there, my lord, appointment of the Vice Chancellor of a state university was challenged. That has been set aside by the Supreme Court. And you have to follow the UGC norms.
Yes, sir.
So, my lord, what I pray...
May I please, your lordship, I am appearing for state respondent 1 to 3. And your lordship, as per Annexure 12, a specific age limit is given, your lordship.
No, I have challenged
Annexure
that.
12.
Annexure 12, page?
Page 115 and relevant page is 117.
Okay.
Well, that is repugnant. Has to be repugnant.
32 years.
UGC norms. 32 years.
32 years plus 5.
Yes, anyway, I heard Mr. S. N. Counsel for the petitioner. Issue notice. MS Esperat Saji is present on behalf of respondents 1,
2 and 3.
2 and 3, and
For respondent number 10.
Ms. Apradhan by Dr. M. Mozika for
Respondent number 10.
10 and 10,
10, 11 is UGC, Your Lordship.
and Mr. Bidep present for respondent number 11. Steps to be taken by the petitioner for issuance of notice on the remaining respondents within 3 days. This matter after
7, 8, 9.
4 weeks.
I mean, the appointment will be subject to the outcome of this. That
I
was
don't need to say that.
Item number 4.
Well, other private respondents I will take by registered post.
Yes, within 3 days. Yes.
How much?
Your Honor, this petitioner was left out, Your Lordship. There is some mismatch in the date of death. And earlier, Your Honor has allowed similar petitions because age was not the consideration for substitution. And only this petitioner is left out who could not be contacted. Serial number 4 at page 12.
Page 12.
12. And
what's the real date of death?
It is 23rd May 2012 as per the Ningrim certificate. Page 16. 16, page 16.
No paragraph in your petition?
3, my lord.
3.
Para 3. Yes, this misapplication has been filed with applicant to the effect that the date of death as mentioned in
serial column number 4
in column number 4
of order dated
13/10/2022
passed in
Miss case number 7
5, 6, 7 yes 7, Your Lordship,
7
of 2022. Sorry, Your Honor, 8.
It's Miss case number 8 of 22 in FA number 1 of 2022 be read as 24/5/2012 instead of
23/5
instead of 4/6/2020. Oh, instead of
yes.
Be read as 24/5/2012 instead of
4/6/2020.
8 years difference. Don't know when the person died.
That Lordship, because at that relevant time Headman was not there, so in this case also
Anyway, like in the other case we can understand. Yes, okay.
Because all were procuring from Headman.
Be read as 24/5/2012 instead of
4/6/2020.
Yes, as mentioned, that certificate dated
25/6/2012, issued by
the Negrims,
Registrar of Death and Birth, Ningrim, Shillong.
Negrim, Shillong, Meghalaya. Noted submissions made by the legal counsel of the parties. The application is allowed. Registry to make necessary corrections after substitution before the lower court has been effected and inform this court accordingly. This case disposed of.
Main list, item number 1.
The matter is likely to be settled. I think government is trying to settle the matter.
Is that a fact?
Lordship, as per my latest instructions, there was a proposed formula which was proposed to the government by the Education Department, but that is still yet to be decided by the government, Lordship.
So what will be the fate of this matter then? Does it have any bearing on that, or the settlement is independent of this proceeding before this court?
It is up to the government. If the government
is independent, is the proceedings for settlement? It's for fixation of those. For these salary.
Just for release of the area of salaries only.
Is it
admissible?
Connected to this matter?
Because in earlier affidavit filed by the government, they admitted all the claims that yes, they are the people entitled the area of salary. Subsequently, they have challenging.
Mr. Qureshi, as also Mr. H. for the petition, as also Mr. H. Kharwanlang for the state response submits that the matter is still under consideration by the state respondents with regard to the mode of settlement. They pray for and they pray the matter will be settled after 6 weeks.
Yes.
Just after 6 weeks. Yes.
Obliged.
Item number 2.
Yes. Where were we? What matter about?
Inquiry, my lord. A certified copy of the inquiry report.
Inquiry regarding?
Regarding the Gaubuda, my lord. Before he was heard, my lord, the allegation is that principle of natural justice was not followed. So he was heard. This is a certified copy of the inquiry report. If my lord, you may kindly see 6/12 order, 6/12/2022.
Order of this court.
Order of this honorable court.
Yes.
My lord, second paragraph, my lord. Mr. H. Mia, learned counsel for the petitioner, submit that termination of the office has been done without following due process of law. Though he admit that after the show cause was filed, an inquiry had been conducted by the respondent, he fairly submit that he was absent. A statement has been made before this honorable court, my lord. But the inquiry report says something else, my lord. It is something very serious, my lord.
My lord, this inquiry report is like page number 40, my lord, in my petition.
Let's see the inquiry report first. Your statement is here, last page. I see Zulfikar Ali Bhutto strongly condemn against allegation placed by C. Ibrahim Mia and party. He stated that the house in Sangimari is on rent and visit it on monthly visit. I have never misbehaved with the people if I have to be during conducting work which is sometimes needed. I have sometimes asked for ₹20 during doing work for the cost of a written pad which they pay accordingly, not mandatory. So,
my lord, I got termination. The input order dated 16 August 2021. That is the page number 43. That it's clearly mentioned that they are not satisfied with my show cause reply. So that's why they terminated me. They didn't say anything about the inquiry report and so on.
Doesn't matter, but they've done one step further. They've heard you also. They've recorded your statement.
Yes.
You signed it also.
I signed it?
Yes. Your signature is here. You give him a copy. Have you given him a copy? You withdraw this matter, otherwise will levy heavy cost. You signed it last page. You signed it. Signature is different from the verification of. This is your signature.
I don't know, my lord. I have to clarify with the petitioner.
These
You're not going to go into, proving.
I don't know, because my lord, I got the inquiry, sport inquiry on 21st.
No. See, what do you say about this inquiry report? Why would they produce a separate
But this is my
inquiry report?
signature or not, I don't know, my lord. I don't know. So that's why I have to clarify with the petitioner only.
Obviously, it will be in the petition also. His handwriting only.
Yes, there. But is this? But who signed the petition? Does this deponent sign?
And my lord, my termination was not about that inquiry report. My termination was the show cause reply only.
See, show cause reply is fine. You filed reply, and even then you were heard, your statement recorded, and you signed your statement also that I've taken, but it's not mandatory. I've taken for writing pad. He said, no. The allegations is that I shouldn't have taken any money from the villagers for issuing certificates.
But after inquiry report, they send me the show cause also, my lord.
And even then, they have said that that's the 20 rupees per person.
Yes, 20 rupees per person. I already mentioned in my petition also.
Yes,
and
that's also the charge against you.
But the Meghalaya Gazette, the order is there, my lord. I already put the order also that I can take 20 rupees from his for issuing the certificate. My lord, the page number is.
Is not relevant to us.
39 page number. That is my main petition, my lord.
Let him meet that, because he says he has not been heard.
39.
It is not applicable to us. Garwell District Council doesn't follow, my lord.
Garwell also comes under the Meghalaya Gazette only, my lord.
No, my lord. We have not adopted this, my lord. We are following Assam Land and Revenue Regulation, my lord.
Anyway, the thing is that we'll dispose of.
My lord.
My lord, please give me one.
We're not going to continue further.
Because my lord, I already put the Meghalaya Gazette order also.
You've been terminated since. Your term was for how long? Till? What was your term when you elected the first time?
First time I elected, my lord.
This time, I mean, when you before suspension, what was your term?
2006, my lord.
The terms for how many years?
It's not mentioned.
Not mentioned, my lord. My lord, in the Meghalaya Gazette, it's clearly mentioned that Garo Hills also comes under the Meghalaya Gazette only.
This is your signature only.
This is his signature.
Page 42, Annexure 6 of your petition.
Page 42 is show cause reply, my lord.
Yes, page Annexure 6. See the signature there and the signature in this statement which has been recorded.
Same, my lord.
Yes, the 20 rupees I took, my lord. I already admitted. The 20 rupees.
Signature. When you're saying what you want to get instructions, whether this is a signature of the petitioner or not.
No, that one though I don't know, but I already admitted.
I've given.
Look at it. Look at page 42 and look at this. Don't play with the code, Mr. Mia.
Page 42 of your petition. 42.
You understand you have a lot of concern?
Yeah. This signature and this signature is same, my lord.
Oh, this one the same.
Is
Yes,
same.
yes,
Yeah.
same.
Then
Same. My lord, I already admitted that I took 20 rupees for issuing the certificates, and that one I got from the Meghalaya Gazette order. So I was following the order only, my lord.
What about the other charges? You see, what do you see? And insist on I have never misbehaved with people, and if I have, it would be during conducting work, which is sometimes needed. So you have to misbehave sometimes because it's needed, as per your statement.
My lord, I many times I was asking the report only, the inquiry report, but the office didn't give me the report also. From 21, I was asking the reports, but they didn't give me.
Yes. We'll give it a chance to make a representation. Let him make.
Yes, please may fix for hearing, my lord. Direct final argument.
There's no need for hearing. As directed by order dated.
Order dated?
My lord, please may allow me to file a counter.
Where's the question of
counter to what? What the? In compliance to order dated 6/12, we said. No?
6, yes, ma'am.
6/12.
6/12/2020.
6/12.
Well, this one, though, my lord, this inquiry report is before the show cause, not after the show cause. This one is before show cause. Because
Where did you file a show cause?
Show cause.
Page 42, come.
Yes. Show cause notice dated 12/7/2021, page number 41, my lord. Page number 41. This one not the my lord that
Okay,
report.
yes. What do you call it? Pursuant to order dated
Yes.
16/12/2022, Mr. S.D., the standing counsel for JGDC, respondents 2 to 5 has produced an inquiry report. A perusal of the same reflects that an inquiry had been conducted with regard to the charges against the Gaumbura, and in the inquiry itself, in the inquiry itself, it is also seen that the statement of the petitioner was recorded. Stop. The writ petitioner pointed contention before this court is that he was never heard, and after he was allowed to file a show cause, which he replied on, was the date?
Reply date, my lord, 15/7/2021. The show cause reply date.
15/7/2021.
Yes.
He was,
that is page number 42, my lord.
Suspended from the office of the suspended as Gaumbura based on the said show cause reply. Stop. Next paragraph. Mr. H. Mia, and counsel petitioner, though not disputing that it is a petitioner's signature on the inquiry report which was conducted on
10 February.
10 February.
No, my lord, this one is okay. I admitted this one. The signature is fine.
Yes.
It's okay.
It is conducted by
But
the reviewing officer and report submitted on 10 February 2021. However, further submits that the show cause called for was subsequent to the said inquiry, for which he had replied by way of the show cause reply dated 12 July 2021.
And on 16 August, I got terminated.
21, after which he was terminated on 16/8/2021 by the respondents 1 and 2. The counsel then submits that the proceedings which had been adopted in the manner of his suspension, the suspension or termination, the manner of termination has been irregular and not in accordance with but because you've been heard twice anyway, has been irregular, which has caused severe injustice to him. Stop. It is further. Stop. Next paragraph. Mr. S. Day, legal counsel for the GGT, submits that there is no irregularity in the proceedings, inasmuch as in fact the writ petition has been given more than adequate opportunity to answer to the charges.
No, my lord, I got just 3 days time for answer the charges. I got just 3 days.
Listen to order. Inasmuch as apart from the inquiry that was held, where he took part and a statement was recorded, was even afforded a second show cause, which was then filed by the petitioner, and decision was rendered by the respondents accordingly. Stop. He therefore submits that the matter calls for no interference, and the petition being without any merit is liable to be dismissed. Stop. That is his submissions here. I've heard the counsel of the parties. I would consult the parties and peruse the materials, especially the inquiry report, It is noted that the writ petitioner has appended his signature, which is not disputed by the writ petitioner, and the fact that his statement has been recorded as to the allegation therefore cannot be disputed, or cannot be questioned. Stop. Next. The other fact that also cannot be that is seen from the records is that he was allowed to show cause again, show cause to the charges which he replied to as referred to earlier. Stop. Though no irregularities can be said to have been committed in the proceedings, inasmuch as the ground taken that the petition was not heard is not correct. However, we'll just give it time to represent. However, for the ends of justice, the petitioner will be entitled to one hearing before the respondents on the basis of the second show cause that he has filed. Yes.
Second show cause, they didn't. I mean.
Yes, on the basis of second show cause. Yes.
Okay.
They will file. Next part of the matter of money stands closed disposal with the direction as with above. It is understood that the respondents shall dispose of the matter ex officio as possible, possibly with a period of 3 months from the date and orders produced before them. Okay. At least if you want that, no? You said I filed my show cause on the basis of show cause they've terminated me. They have done inquiry before. Let them look at all the materials. Then you can even say that the 20 rupees is allowed.
Item number 3.
Okay. Otherwise, yes.
See, I have received the copy only day for yesterday. I have sent to my client just to ask him the clarifications about this affidavit. Maybe matter may be taken up next week or.
Yes, Mr. M. said he just received the copy of the
affidavit filed by the government.
Why?
Because
by respondent number.
By the government, they want to bring
respondent number. At least assess the code by respondent number.
1 2.
Additional affidavit. It's not affidavit.
Yes, additional affidavit.
It is additional affidavit.
Mr. Murki submits that he has just received a copy of the additional affidavit filed by on behalf of response 125 and says without 2 weeks to file the rejoinder. Yes. They are allowed lists thereafter on so and so.
Item number 4.
It's for hearings on today.
Fixed for order, Your Lordship. Your Lordship, last date. It's fixed for orders, Your Lordship.
Your Lordship, as per the last order, is supposed to be fixed
For hearing.
Yes. Start. What is the case about?
Your Lordship would like to fix the hearing on the next date, Your Lordship.
Hearing is date. Okay. Family pension?
Yes, Your Lordship.
Why you want to delay? Yes, the council petitioner placed the matter B. This is for hearing on when? You choose your date?
After 2 weeks.
After 2 weeks.
Highly obliged, Your Lordship.
5.
Hearings are complete. As per the last order also, it was supposed to come up for hearing, my lord.
No, have you filed rejoinder? You asked for rejoinder, Mr. Pathak.
My lord, I have examined, my lord. Rejoinder would not be required, my lord.
And last time it was not posted for hearing because he had asked for, you prayed for rejoinder. Anyway, Mr. B. Pathak submits that on examination of the affidavit, no rejoinder would be necessary. Accordingly, he prays the matter be listed for hearing. Yes, prayer all is the matter for hearing in the usual course on so and so.
6.
There is a connected petition, 31 of 23, my lord. Maybe tagged together, my lord.
Is it listed today?
No, my lord, it's not listed.
Is that correct? Who's appearing? Is that correct?
31 of
Any other 31 of?
2023, my lord.
Is it
In which
connected
also
to
the
this
pleadings
matter?
are.
No, we want to list it, yes. Though Mr.
Hello,
Perfect has submitted that WPC number 31.
31 of 20.
31.
My lord.
31 of?
31 of 23.
23 is
23,
connected. However, the council appearing for the union does not have any instructions on that.
Item number 6.
Yes, yes.
Sir.
Obliged.
Yes. No one appeared last time.
Yes, sir.
So what do you want?
We want reinstatement of the service and dismissal of order to be squashed, sir.
Which order to be quashed?
Dismissal order by Assam Rifles dated 27 October 21.
Where is that?
This is in Annexure 4.
This is recovery of excess pay. It's not order of dismissal.
No, this here delay from service with effect from.
Where? Which page is that?
Dismiss page 13, 14, 15, sir. Dismiss number from service with effect from.
How many days were you absent?
He was absent for.
Where Dr. Mazikar?
He was sick. He was actually sick. He was hospitalized since 26.
We will have another day.
Okay.
The pleadings, as no rejoinder before coming from the petitioner, the pleadings are complete. This matter for hearing. Yes.
Item number 7.
My affidavit is ready, but my lord, the officer will become able to come only on Thursday next.
We're not bothered about the officers, what they miss. That excuse won't go. Where's Mr. Hassan? Who's the current headmaster?
In fact, our client, Hassan's client, he has filed the affidavit bringing on record.
Yes?
He has filed one affidavit bringing on record that he is the headmaster of the school now.
Yes? Regarding? We want to file a Mr. Kivi Versace and for 124, GA 124, and your name? And MSM Rahman on behalf of 105. Pray for and allowed 2 weeks time to file the affidavit.
3 weeks.
Just thereafter.
8.
Hello.
Lord, we have already filed the affidavit in the last because of the
Your respondent number?
3 years. I'll file my rejoinder.
You'll file the rejoinder?
Yes.
You already filed it?
Not yet.
Your Lordship, we are respondent number 1 and 2. We have not received any affidavit from the respondent number 3.
It's in me with me only, Your Lordship. I'll share my affidavit with you.
That's between councils.
Yes.
That's generally not notice of court anyway. Oh, you for the hot Robert Hospital, yes. Learned Council is so and so admits that the affidavit on behalf of respondent number 3 has since been filed, to which Mr. D. Hinyota prays me allowed to file rejoinder. Yes, just after 2 weeks for rejoinder affidavit.
Right.
9.
Because it's sought directed as to obtain instructions insofar as that second list is concerned. Because what had happened is, in respect of the person appearing at serial number 3, there was some complaint
Number
There was
3.
some misrepresentation, because I'll take your lordship to page 44, Millets, and Lecture 6. He was Mr. Ephraim Sinkley.
Number 3, yes.
There was some misrepresentation made by him, Millets, for the purposes of being his name coming into the list. So, Millets, after the complaint, Millets, the records were verified. It was found that the complaint was genuine, and his name was removed. That is how, Millets, the name of the person appearing at serial number 4, Millets, came to be at serial number 3 in the next list that was published by us. 86 Millets.
86.
The lordships will see that the names are the same. This is only serial number 3 is removed, Millets.
Kemborlang Marbanyang has come as number 3.
Yes, Millets.
Right. Yes.
So, and this is the list, Millets, which is as per merit, as per the total marks obtained by the parties.
Lordship, in this case, the records may be called, Lordship.
Yes?
Records may be called, Lordship.
Why records may be called?
Yes, Lordship. Because, Lordship, here, Lordship, as my senior has said that at serial number 3, he was his name has been
removed.
Yes, yes. So, Lordship, even still, Lordship, the respondent number 9, sorry, Lordship, the respondent number, private respondent, that is it. Yes, Lordship, respondent number 8, his name is appearing at serial number 4, but his name was not there in the anywhere in the list, Lordship.
Let's see the first list.
Yes, Lordship.
In the first, where the first list? First list was page, where was that?
Page 44. Page 44.
Page 44, okay. 44, you see which number?
Lordship, the respondent number, the name of respondent number 4 is stand at serial number 4, but his name was not there in the first list.
Skemborlang is serial number 4, Millets.
Respondent number 11. Mr. Deb, you at least assist the court.
Yes, yes, Lordship, that is
Talking about respondent number 8.
yes, Lordship, respondent number 8, his name was not there when the first notification was issued, that is annexure 44, but subsequently when they have published the second notification, his name came in the serial list.
Serial number 4, Millets.
That is
this
to
is the merit list.
SB as per the.
That is to in order of merit, Lordship. So, Lordship, that's why the record may be called.
Respondent number 4, respondent number 8, who appears at serial number 4 at page 86, Millets, he had secured more marks than these other 5, 6, 7. People appear at serial number 5, 6, 7, so therefore his name was.
Oh, right. No, because these are Garo candidates.
Yes, Millets.
So,
Lordship, records may be called, Lordship.
There's no confusion, Mr. Deb. The thing is that after that one name was removed, then you have to pick out another name from the Khadi gender category to come here. And he had got more marks than the other Garo candidates. So that's why he'll be on top as per the merit list.
That is why, Lordship, even I may have also got the marks more than him, because, Lordship, I have filed one RTI seeking what is the marks he got, but they have replied that I've been exempted under section 8 of the RTI, so I cannot get the information. So that's why, Lordship, my name was not included. So that's why maybe.
So what interest will they have to put some other person whose marks are lower than yours and to deprive you?
Lordship, just simple prayer, Lordship. Records may be called.
There is no allegation of malafide as well.
Lordship,
have you made allegations of malafide? That there's been what do you call it? Manipulation.
No, actually,
in the results to accommodate the certain respondent.
Lordship, they are claiming they have accommodated him on the strength of a subsidiary list. They are claiming.
Subsidiary because as your counsel submitted because there were some complaints against the earlier list with regard to one candidate, and after verification was found that was correct, and so his name was removed from the merit list, and in his place the next candidate will come.
But, Lordship, there is no definition of subsidiary list in the Meghalaya Public Service Regulations, Lordship. So, from where they have got this subsidiary list, Lordship?
It's not subsidiary list. This is like a corrigendum.
Yes, Lordship. So, his name came out from subsidiary list, Lordship.
Otherwise, also, well as the writ petitioner.
You are on the main list.
Lordship.
Your name is on the main list.
No, Your Lordship.
Then is the subsidiary list only.
Probably, Lordship. I do not
It
know.
is all in the substitute.
I do not know, Lordship. That's
Yes,
why.
Mr. Paul. What is his grievance? I've not been able
Well,
to understand really.
he has secured lesser marks than another 3 candidates. The candidate at serial number 1 from that list has been brought into the merit list.
Yeah.
After that, there are 2 more persons, and then my learned friend's client is there. So otherwise, also he secured lesser marks than the persons. Well, we have nothing against him. If we had got the marks, we would have put him on the list.
Lordship, my small prayer is that records may
This
be
is
called.
result sheet. That's all. Can produce it,
produce
yes.
the records.
Yes. So after hearing it, after hearing the parties, it appears that the records, especially the result sheet, is necessary for proper education of the matter. When we produce it?
Next week, Lord.
Yes. List after 1
The
week.
Lordship will require us to produce the result sheet.
That's the result sheet to show the result sheet and the tabulation to show where the red prejudice.
I do not know what purpose it will serve, my lord. Lordship goes by their prayer, my lord. No prayer is made to appoint him.
Yes,
Only
basically.
what he wants to oust the private respondent. Kindly see his prayer.
Is that correct?
Yes, yes.
Kindly see.
The prayer is only against the private respondent.
No, then, Mr. Dev, I am sorry.
At page 24.
Sorry. Yes. Where is that? That is want to remove the respondent from the post.
My lord. And further, there is no prayer to appoint him.
There is no positive prayer on his part.
Lordship,
And my lord, this is the 4th round of litigation, my lord.
Lordship, there's a ground for why I have not prayed, Lordship. They have already declared me unsuccessful, Lordship. So even, Lordship, when I prayed to supply me
No. See what
Lordship.
is correct. Now you're asking for direction to remove the respondent by 8.
Lordship, my first prayer is Lordship.
How is that sustainable?
Lordship,
He should have made a prayer for a declaration that he is successful, my lord. That is what. He is not.
Some positive direction
not
on his
even a single
behalf.
whisper, my lord.
So in that case, Lordship, I may be allowed to amend.
Amend what?
The prayer, Lordship.
We would have objections to that. Well, as have been.
Just 4th round. We'll dismiss it, Mr. Dev. We'll do one thing. We'll give you one chance of hearing next week.
All right, Lordship.
Yes.
I have produced the records for my friend's satisfaction.
Yes. Just for 1 week. Otherwise, you're not going to get the relief. Remember that. Yes.
Second call, supplementary list item number 2.
Yes.
May I please, your lordship? Lordship, my petition yesterday was for my grievances was against the respondent number 3, number 2, number 3, and number 4, lordship. It was because they had expelled the villagers, the residents, from without allowing them to take part in the village darbar, lordship. That was number 1, lordship. And then the number 2 was their residential certificates were denied to the villagers, and there was no clarification for the same, lordship. And then number 3 was that they just the Sardar, that is the respondent number 3, along with some other people, they come and then they just beat up, they assault one of the resident, lordship, who was against all these, lordship, who was there. And lordship, all these were reported to the respondent number 2, but failure of the respondent number 2 to act on it had led to all these arbitrary actions by the respondent number 3, lordship. And so this was pointed out to the respondent number 1 to look into the matter, lordship. Then respondent number 1 in fact had directed the respondent number 2 to look into it, all these actions and all, lordship. But nothing had happened. They did not comply. Respondent number 2 never complied with that, lordship. And lordship, the last one was, before filing of this, a notice was received from the respondent number 1, but by that time, lordship, we had already filed this petition and we were already before them.
What notice has been issued by respondent 1?
Lordship, the writ petitioner's prayer, whatever substance of allegation perhaps may be correct or may not be correct. And be that as it may, we have taken action on the subject and we have issued notices to all concerned parties just on 24th March 2023, and perhaps you must have received it also. We are seized with the matter. We understand the gravity of the matter. There is a civil suit also between parties, between this Ramashnong and this Council Court. Be that as it may,
That
we are
is
seized
we
with the
are
matter.
Lordship.
Then you
That is a civil suit, Lordship. That is a
take down. The writ petitioners are before this court alleging that in spite of complaints made before the respondent number 2 and 3 against the village elders for excluding them from Darbar, no action was
denying
taken. No action was forthcoming. Stop. It is a further case that also approached the office of the Executive Committee on 22nd April by way of our complaint, but that the same is yet to see the light of day. Stop. Though the writ petition does not really reveal any impugn action, it does not reveal or know any materials been annexed to show that they have been expelled from the Darbar. However, as the matter involves a community, it does not reveal any such action on the part of expulsion. The learned counsel for the petitioner submits that the grievances are
number one, so, Lordship, denial of taking part in the village tour.
They have not been allowed to take part in the Darbar.
Number two is the
they have
denial
not been
of
issued, nor they've been issued residence certificates, and
Lordship, they were assaulted without any rhyme or reason by respondent number 3.
You file an FIR.
Yes, Lordship, that is filed, Lordship. FIR is already there, Lordship.
There have been FIR. No, not there have been not shooting stuff. Next paragraph. Mr. VG Kanta, seat special counsel for the KGC, submits that perhaps the petitioner are aware that the matter is seized by the respondents number 1 and 2, and that notices have been issued.
Yes, Lordship, it was too late for us when we received.
Concerned parties to appear before it for settlement of the matter. Stop. Right, but in this view, the matter as the grievances of the writ petitioners are being looked into by the respondent 1 and 2, nothing survives for consideration. Number 1, nothing survives for consideration presently in this petition. The same is disposed of.
Lordship, at liberty, Lordship, if anything, Lordship.
Liberty, the new cause of action, you always
take action.
Hearing.
Highly obliged.
Item 5.
My lord. Lordship is kind enough to fix the matter today for hearing of this petition. My lord, some issues according to me involve whether, my lord, number 1 is government has taken over the position or not. Second is, my lord, whether the government has taken decision to take the land or not. And my lord, there is a decision also. Once the government take a decision and communicate to the parties, my lord, whether that is binding to both the parties or not, my lord. And another issue is whether, my lord, government can take a plea before this court against its own record. The lordship fixed the matter. Now it is my duty, since I invoke the resolution of my lord, I have to satisfy my lord that there is no disputed question of facts. And to ascertain that one, my lord, there is Supreme Court decision also how to ascertain by this Supreme Court whether there is a disputed question of facts or not. The Apex Court held that the court is required to see the affirmance. The court is required to see the pleadings and the records, my lord. Yes. Then it will show whether there is a disputed question of facts or not, my lord. Earlier, my lord, I have taken some annexures to my lord attention. I may not repeat that one, but I'll just take a few annexures from that main writ petitions and go to the affirmation given by the respondent state, my lord. Now,
Yes.
my lord, may I take now? I take lordship attention to page number 147. That was the communication on the basis of the representation. Earlier we read together. I'll come back later on that one. Now, the relevant portion my lord may come to page number 151. In the first round of litigation also, when the matter was pending, the communication was given by Deputy Commissioner Collector to the department that if you want to proceed the matter, department is required to proceed under the new act. Page number 151. My lord, that was the letter 15 February 2016. Now,
151.
My lord, 150.
Annexure 6.
My lord, Annexure 6. At the bottom, my lord, I may read, my lord. Please note that in case your office still intends to proceed with the land acquisition, sections and such as I mentioned above in the earlier letter will no longer be relevant. Instead, action has to be initiated as per the new act. So this was communicated to the department. They did not bring on record earlier round of litigation. If that is made, my lord, after the presentation was disposed of and communicated to me, there was a consent between the collector and the department to go ahead with the, my lord, proceedings. Page 152, my lord, page number 152.
Yes.
My lord, it does read, my lord, 18/7/2018. That is after disposal of the representation and communication to me. Land acquisition for construction of Sons and Sons, my lord, later refer. With reference to the subject and later referred to above, I have the honor to inform you that on a survey of submerged areas of land due to construction of Sons and Sons combined water scheme, they use the word submerged land, my lord. Deputy Commissioner Iskazir Shillong made an assessment for compensation and an amount of rupees and such, my lord, which was communicated to the department by number Sons and such. So they did not use the word. It is not damages, it is a compensation. In the affidavit later on, my lord, they say it is a damages calculation. I'll come, my lord. It's a compensation. Therefore, a proposal for an amount of rupees such and such was sent to the government on December 2012 for sanction. However, sanction was accorded only for amount of rupees such and such, my lord, on 29 March 2018. That's after disposal of my representation, with the direction that estimate for a balance amount of rupees and such is sent during the financial year.
Mr. Chaneso,
my lord,
this letter I referred to is 15/2016.
My lord, there also.
So that means over 2.5 years, then the next letter came.
My lord, yes. In the new.
The thing is that, see, that was it's 15 February, right, by the Deputy Commissioner to the superintending engineer.
My lord.
Okay, that is okay, fine. Please note as you proceed, second 4. Okay. Then after that, executive engineer, after 2 years.
My lord, there was, when this letter, Annexure 6 was written, the first writ petition was pending. And the state filed the affidavit. They did not bring on this record.
Which one?
This is Annexure 6. They did not annex this. So this time I'm trying to pursue, my lord, that even at that time also, collector has made known to the department that if you want to proceed with taking the land, it has to be.
What is the earlier WPC number?
WPC number, my lord. My lord, that one is. But the WPC number, my lord, 117 of 2016.
117 of 16.
2016.
Okay.
My lord.
Yes, continue.
Well, now, thereafter, my lord, the case was pending and the single bench decided, directed matter to the Deputy Commissioner to take a decision. We were agreed with that. Under the Land Acquisition Act, government has to take a decision, not the collector. So we prefer appeal, and the Learned Division bench directed the Chief Secretary to take a decision.
When was that? In?
My, that is. Noted. That decision is available, my lord. Page number 138. 138.
138.
My lord. 138. And may I read from page number 139?
Yes.
May I? Learned GA, on the other hand, seek to contend that the counter affidavit as read as a whole makes it clear that all the relevant facts were stated before the court for consideration, including the fundamental fact that the proposal for payment of compensation to the concerned landowners whose cultivation is likely to be affected due to the submergence of the land for a period during sunset was formulated by the PHE department and was sent to the government for consideration, and the same was pending consideration. That was the stage. Taking note of the submission made and the pleadings of the parties, we find no case for interference at this juncture. Well, it is important at this juncture, when we are inclined to endorse the views of the single judge that the appellant petitioner ought to make appropriate representation. Such a course appears moreover necessary in view of the several disputed question of facts being involved in the matter. However, in the totality of the circumstances, we are of the view that instead of requiring the Deputy Commissioner to take a call on the representation of the appellant's petitioners, appropriate would be that such a representation made to the Chief Secretary to the Government of Meghalaya, who may take appropriate decisions thereupon expeditiously. Accordingly, in view of the above, while we decline to interfere and this court appeal dismissed, but subject to the modification of the order impugns, that the petitioner appellants may make appropriate representation to the Chief Secretary to the Government of Meghalaya within 4 weeks from today. Upon the petitioner appellants making such representation, it would be expected to the Chief Secretary to take an appropriate decision thereupon expeditiously, preferably within 90 days of the receiving of the representation. So that was the direction. At that stage, my lord, the department take a plea that proposal was made. Government never take decisions. Because of the efficient pensity, you take a decision. Thereafter, my lord, we find a representation, page 141.
No, that's all right.
My lord. And thereafter,
come back to that 152 then.
Yes, my lord. And after disposal of my representation, this was the communication given by department to the collector.
The representation disposed of on?
On, my lord.
But we disregarded that letter because it's very,
yes.
I don't know whether it's here or there. We are looking
I'll come to that.
Refresh.
Page number 151. The communication given to me.
Yes. Okay.
But Chief Secretary has disposed of that representation.
14 March.
My lord. On 13 March, he disposed of, and communication given to me on 14.
Okay,
the next day. My lord. Thereafter, my lord, after that, page number 152.
See, because disposal was not disposal on the merits of representation.
My lord, I'll
that is
come
why.
to that.
So that you have to now you agitate your case afresh from the facts that are already there. And what is because the main hurdle you have to climb is with regard to disputed facts.
My lord, I'll make an attempt to overcome that one. That was the.
But this court tried to help by getting an inquiry done, but inquiry also neither here nor there. So that is why it case come back here.
Well,
yes.
But my lord, this has to be read with the my lord.
Yes.
Page 152. Now, this was the communication. Now, it says, consequent upon the sanction, it's in the middle, my lord. A check bearing number such and such, dated such and such, and for an amount of rupees such and such, was placed at the disposal of the office of the Deputy Commissioner. Now, the estimate for the balance amount rupees has been sent to the government, and once the amount is sanctioned, it should be placed at the disposal of the office of the Deputy Commissioner and such. Since the exercise was carried out during the years and such, when the Land Acquisition Act in 94 was in force, on account of delay in sanction, it's the admission of the department.
Yes.
The purview of the Land Acquisition and such perhaps be exempted from this. So what I gather from this here, after pursuant to the disposal of my representation, pursuant to High Court Division by direction, the government has taken decision to take my land. And pursuant to that, my lord, he has communicated, sanction was placed, sanction was given. 5 crore was sanctioned. Now, remaining balance will be given to you during the financial year. Now, second portion he is trying to seek is that since the exercise was done earlier, prior to the arrival of the new act, please kindly exempt the 2013 act.
Yes, okay.
That was the communication. Now, later on, my lord, the collector perhaps refused because there is no power conferred upon the collector to exempt. Therefore, the next page, page 154. 154. Department has communicated this again.
What is this 153?
150, my lord, it is an ineligible one. So we have the type copy is page 152.
Oh yeah.
My lord, type copy.
154 now, yes.
Now 154 it says, my lord, another letter, 29 August 2018, refer to 2 letters, my lord. Inviting a reference on the letters referred to on the subject above, I have the honor to request you to kindly reevaluate the amount of compensation to be paid to the landowner of the submerged areas of the land, my lord, due to construction of RCC Dam of Watangai Combined Water Supply Scheme, as per the Census 2013, my lord. The details of the submerged areas, my lord, of the land are enclosed herewith for your favor information in this action. Now it says now please kindly go ahead, reevaluate the compensation, not the all
Reevaluation.
Reevaluation. Because earlier 6
For a new
crore,
act.
my lord. Earlier amount was under the old act. Now say that it should be under the new act. Therefore he said, oh, go ahead. And to do that exercise, department has also furnished the submerged areas, the map of submerged areas. And the submerged areas, detail maps, my lord, we have annexed. Page number 150, my lord. Page number 156.
Page
156.
Okay.
156. My lord. So this was survey.
Where is submerged area?
My lord. Okay, survey was in the month of in the year 2011. Now all the names of the petitions are here. All the names of the petitions are here. Now at the bottom I read, my lord, survey was conducted as per boundary indicated on the ground by Shri Such, Executive Engineer PhD, Shri Such, Justice Such, my lord, such. Landowners are also there, my lord. Now the signatures, my lord, signatures are also there, my lord. Deputy Commissioner, the parties are, my lord. Plot boundary, wall, my lord, water river. So these are the detailed maps prepared by the Survey of India, a survey department, government of Meghalaya, along with the Deputy Commissioner and the PHE. So on that basis, my lord, the collector proceeded for re-estimation. And the re-estimated amount is available page number 157. 157, page 157. 157.
Yes.
My lord.
That's
Now,
7 December.
My lord, 7 December. And communicate to the Disaster Department for necessary approval. And this is under the new act. I may come to the amount one, page number 160. 160.
One?
160. The ending part of that letter. Total amount they have mentioned here. At the bottom, I just read out. Certified that the estimate is fair and the rates have been arrived at after local inquiry, inspection on the ground, and with reference to the settlement report, village notes and papers, and the records of the registration department. So communication was made.
Now this cost has come up from 6 crores, 78 crores?
Yes, that is the escalated amount, the collector said.
That is how much?
Under the new act.
The rise is...
It's jumped
how many times?
Right. 5, 6, 7 times. There was a jump.
This is without any signature, my lord.
Well, it will come. We will come to that one.
No signature.
My lord, I'll come to that one. With lordship permission.
Probable cause?
Yes.
Oh, now we get it.
My lord.
This is as submitted by PHE. That's why they escalated the cost. It's not assessment of the Deputy Commissioner.
But this is
see that letter is 7th December. But I am to the estimate of as submitted by PHE. So this amount we will not take into consideration.
My amount may be less, amount may be more.
No.
Yes.
We're not bothered about this.
Yes. Amount
because we are looking at assessment is done by the collector. So collector cannot say that he's just forwarding the amount which is fixed by the Supreme India Electrical Circle.
No, my lord, though the amount is relevant here, I will not rely on the amount also. But the assessment was made by the collector. Assessment was made by the collector.
It's not made by a collector.
My lord, according to me, my lord, it is made by the collector.
No, this assessment.
It is assessment made by the collector.
No.
But I'll come to
disregarded.
But I'll come to the other page. It will come to know. Yes.
As per assessment made by the PHE. It's not by the collector. We disregard that.
We'll come to other page. My lord.
This is actually root of the. This is a contrived report.
But we will.
Amount.
Yes.
Yes.
Amount will be less, but we are not concerned with that.
No,
amount
we are
will be
concerned
more.
by assessment. This be done.
Yes.
If land has been submerged or taken away, that's one part. Your prayer is only that my land's been taken, it's submerged by the dam.
Yes.
And then there were no proper acquisition proceedings.
Yes.
No acquisition proceedings were initiated.
Yes.
But then nothing happened.
Yes.
Amount was submitted. Then it had come a new act.
Yes.
So after that, it stopped there.
Yes.
Now there stands that no lands required.
Yes.
No lands required.
That is a statement of evidence, my lord. Now page number 162. Thereafter, my lord. My lord. Here the department has written letter to the collector. It says, my lord. Now, inviting reference to the letter and subject referred to above, I have the honor to inform you that an assessment estimate on compensation as per legislation
Received, yes.
has not been received by
Right,
the
that's-
office of
that's
the
correct.
undersigned. However, only the
Correct.
forwarding letter. Now, so he is seeking for, my lord, receive and shall be
That
submitted
means,
to the government for
one-
sanction.
Just stop there, Mr. Chandrasekhar.
My lord.
That means this is there was no assessment was done by the collector as per the letter.
My lord, what I'm trying to understand is that assessment was done by the collector, and the department is saying that we don't receive the assessment paper. Therefore, kindly give us the assessment so that I will send for.
I want to inform you that an assessment has not been received by the office of the undersigned.
Yes, not received by the PH department. So ask the deputy commissioner collector to send the assessment paper so that he can forward for government approval, sanction. Page number 162. Shall be submitted to the government for sanction, it says. And in pursuance to that, thereafter, my lord, the letter page number, my lord, 164. Collector has replied and he has forwarded. May I just read the relevant portion? With reference to subject and letter cited above, please find enclosed here with the estimate probable cost of the aforementioned project as per the Census 2013 to convey the approval of the same. Kindly treat this as most urgent.
How much amount is this now?
My lord, this amount, my lord, is an extra, is continued. My lord, the next page is the assessment paper, and it will come the same. I'll show. Page number, my type copy is page 170.
This is 2019.
My lord.
Yes. This is
2018. 2018.
No, first this you're referring to Annexure 12, first February.
Yes, 2019. 1st February. My lord. And the assessment paper was forwarded. The next page, page 165 onwards, till 171. And the amount is available in page number 170.
Same amount.
Same amount.
Okay.
Same amount. Same amount. But thereafter, there was some representation filed by the lawyer. And thereafter, page number 173.
It is not, you see, it's not assessment. Again, that is
It's
the
an
whole
estimates
problem.
only, my lord.
The estimate probable cost.
Yes, probable cost estimates. Therefore,
if it has come from the collector, it has to be a different amount.
suppose now,
Why
my
did
lord.
the collector not do the assessment himself?
My lord, now if lordship, in case, my lord, if I succeed, persuade my lord, my lord direct the government to acquire. Government has to, collector has to make a fresh assessment.
He has to be
pass an order.
It has to be done by
My
the
lord.
collector, not
Therefore,
by...
my lord, therefore, I do admit that the amount mentioned here is irrelevant. It may be less, it may be more. My lord. What is concerned is the land of the petitioner is taken or not, my lord. Now, page number 153. Lordship,
153?
173, I stand corrected. 173. 173. Now, after receiving this estimates, probable cost estimates amount, the department has forwarded to the government for approval. May I read, madam? 14 February 2019. Madam. Payment of compensation to landowners of the submerged areas of land due to the such and such, madam. Inviting reference to the subject as cited above, I have
By
the honor
executive engineer, superintending engineer.
My lord.
Internal of internal office communication.
Yes, yes. For sanctioning, my lord. For sanctioning.
Yeah.
For sanctioning.
Who will sanction?
But it is the government. Thereafter, my lord. Therefore, thereafter.
Yes.
The party, the other parties, the respondent has filed affidavit, and let us see. Till then, my lord, the matter ends there. My lord. They didn't take any step forward. Therefore, we filed this second writ petition. Second writ petition. And in the second writ petition now, my lord, the affidavit filed by the party, my lord, the ground they have taken, my lord. First, may I take the affidavit filed by the department, PHE, ma'am, before I come to the collector.
First?
To the PHE department. Okay. This they have filed, perhaps filed on 13 March 2020. March. Okay. This affidavit swear by Mr. Ton Gopal Wars,
yes.
Additional Chief Engineer.
Yes.
Now, may I take? They have taken two principal ground. I'll come at para 2.
His respondent number?
He's filing respondent number.
79, 10, 11, 12.
My lord.
7 to 12.
7 to 12.
Okay.
He's filing. Now, para 2, lordship, para 3, may I read, with lordship permission?
Yes.
That before averting the contentions of the petitioners, the deponent begs to state that before starting of the Watangai Combined Water Supply Scheme, an agreement was made between the Suki So Rangpash Nong, Nongkin Reed, and such, in which the petitioners Samarman Nongpri, landowner, along with others, have signed the agreement and submitted to PHE Department for construction of RCCU Water Compliance Scheme Watangai, and also where it is stated that at the last paragraph that Srimati Sumaman Nongpri has agreed to donate land situated at Sunset as per the map annexed herewith, and the boundary indicated thereon in connection with the above mentioned water supply scheme free of cost, without any compensation, and free of any charges or taxes whatsoever, and such a land shall vest with the village Darbar from all encumbrances. In view of the agreement, the petitioner have no right to file the instant writ petition, liable to dismiss. So with regard to petition number 1. Now, I further state that there was another compromise agreement between the writ petitioners, except Sumaman Nongpri, and the government represented by the competent authority. Now, this first agreement, they are saying that there was agreement entered by writ petition number 1 with the Rangpash Nong. And there I decided to donate it. Government was not a party in that agreement. I denied this agreement. No agreement was signed by me. Now, the government is taking the plea that since you have donated the land to the Rangpash Nong, you cannot file a writ petition. Now, government did not disclose how they obtained this agreement also. They didn't disclose in the affidavit, my lord. And if that be the case, how her name is mentioned in the survey, how her name is mentioned in the draft section for notification also, and how it was not bring to the notice of the court an earlier round of litigation, my lord. So I deny this. And there was, my lord, second part of the
affidavit. Signature here.
My lord.
Agreement deed is
agreement deed is available there. My lord.
One.
I'll show. Yes. Agreement deed, my lord. This is I denied, my lord. My lord, can you see page number 8? This is the agreement.
Yes.
My lord.
You deny this one.
My lord, I refuse. I did not sign, my lord. And the second page number 9.
Getting deeper and deeper into disputed questions of fact.
My lord, I'll this is how the other side.
See, yes, you're getting deeper and deeper there.
But I'll come. According to me, how the department is trying to be deprive.
No, I mean, like, where does agreement come from? These signatures have to be proven.
My lord?
They have to be proven, the signatures.
No.
Whether he signed it or not.
No. In her reply, she has denied all this.
It's simple to deny. To deny the signature is simple. But then it has to go for forensic, estimation or examination. Yes, continue.
Lordship, kindly see page number 10. Continuation of that agreement. Page number 10 of that affidavit.
10.
Yes. Now even they have Rangpash Nong has prepared this, the map. But this is the first instance where my Rangpash Nong would be able to draw this. This must be from the hand of the technical person, and this is drawn by the Rangpash Nong, showing my land, donating to the Rangpash Nong. But this is absolutely, my lord, afterthought. It was never part of the first writ petition also. Now, that was the plea taken by him with regard to petition number 1. The rest of the others, my lord, they are not claiming, my lord. Now, the second part of that para 3, my lord, there was an agreement also, my lord. There was an agreement. In fact, 2019, December, what happened, my lord? The department invited the writ petitioners to come for compromise. Let us compromise, resolve the matter, we will release the matter, release the amount. Therefore, out of 9 writ petitioners, 8 went. And even the principal secretary has issued notice to Summan number 1, writ petition number 1, and she appeared through her son. And let us reach a compromise. So these writ petitioner, 8 petitioners, a drafter, compromised it on the instruction of the department and submitted to the principal secretary for perusal and signing. Now thereafter, my lord, the principal secretary informed that no, I have to take some more instruction. So the matter was kept pending. Therefore, this the agreement was not signed. This agreement may just show. I have a next in my rejoinder.
What about this report on providing page 12?
Page 12. My lord. Yes, this also they have an X. My lord. They have an X. Now, that is the, I'll come to that rejoinder, I'll show the agreement also later. The second part of the reply, page number 5 of the state affidavit, my lord.
That means the whole project was worth just 10 crores.
My lord.
And then compensation will go to 78 crores.
My lord, that was the, my lord, and it's due to the, my lord, the delay on the part of the department, my lord. Department.
Yes, continue.
Page number 5, para 5 of the affidavit, my lord.
Of the same affidavit.
Of the same affidavit.
Yes.
Lordship, mechanism. Now, after disputing this, they mentioned this again, my lord. They admitted this again, my lord. That in reply to the statement made in para 2.3 of the writ petition, the deponent respectively begged to submit that Wadangai combined water supply scheme was accorded administrative approvals and such 10 lakhs, 10 crore. The scheme is intended to gather drinking supply to villages and inhabitants under such and such, under the Sardarship, etc. The source of the water supply scheme is the river Omiao of the Sansat and small RCC wire across the river Omiao, located at such village for grading necessary head for water to flow the a slow sand filtration plant located downstream, and water is pumped to the main reservoir located at such and village for supply to the villages inhabitants. Gravitational flow and the construction work was taken up during the year such and completed such. It is also stated when compounded with the heavy monsoon rain, the level of water upstream of the RCC wire rise up and inundate some area upstream of the RCC wire for a brief period of during such. During survey of the land in question was carried out 2 phases by the survey of Meghalaya, Shillong, my lord. GPS survey was also done, my lord. Another survey was done on 14 December. But this was continued, my lord. And after survey, 2-3 times survey, now they have mentioned that, my lord, land amounting to such compensated to be compensated. It was proposal was made, and name of the writ petitioner even now, Lord, you can see number serial number 2 is the writ petition number 1.
Where are you reading from?
Page number 3 of the state affidavit, PHA affidavit.
3 or 5?
Para 5.
Okay, yes.
Para 5. At the bottom, 2 surveys were there, and when we go next page number 4, survey was done by the survey department along with the deputy commissioner, my lord. Now the amount they came with this, and writ petitioner number 1 is mentioned here, serial number 2. Now, in the one hand, my lord, they say that I have donated my land to the Darpachnong, and they have included my name in the survey report, everything along my land and the compensation, the amount also. And now, my lord, additional compensation under section, my lord, 323(2). It is a compensation, my lord. It is not the damages. In affidavit I'll come, they say that 6 crore something is the damages. It was never damages, man. It was a compensation under the All Act. Now, this is the admission, my lord, admission. And the page number, para 7, my lord. Para 7. The assessment effectiveness, my lord. Company knows.
Yes,
so,
para 7.
Para 7.
Yes.
That the assessment of the affected area of the land was done by the competent authority in the presence of landowners. So, that was the admission. Now, the dispute they are trying to bring on, my lord, page para 7 and 8. Para 8 and 9. Para 8 and 9.
Yes.
Now it says that with regard to para 6 of the writ petition, it is also stated that there is no proposal from the government to acquire the land. My lord, if there is no proposal to acquire the land, my lord, how sanction can be made? How it was deposited before the collector? It is without any record, my lord. There is no proposal for not to acquire the land, my lord. It is also stated that on the request of the villagers, the scheme was taken up and completed during their census. It is further back to state that the river belongs to the state government and not to the individuals. And the land of petitioner has not been acquired by the government, and there is no proposal for census. My lord, if lordship send any commission, with due respect, profound respect, may submit that if lordship send any commission, authority, or the court to conduct the survey, everyone will know. It is like the Umiam, my lord. There is no original size we can see inside the Umiam. It is the same thing. But in fact, earlier occasion, I had the occasion to go that side, my lord. I even saw from a distance. My friend has visited, my lord. It's like the Umiam only. In Umiam, my lord, original size is no more there. Inundation,
This is
same
the
thing.
Moplang Dam.
Moplang, not in Moplang.
Where is it? How do you get there?
From Nongkandri, if we go up, there's
Left or right?
on the left side.
Where a new highway is coming up.
Yeah, somewhere that area. That road coming from to this Nongkandri, past that road. There's the
No, Allencourt Road, you mean?
yes, Lailancourt from Smith side.
Or-
From Lakra.
Okay.
My lord. And the other second para 9, my lord. The deponent begged to state that the executive engineer PHE Electrica submitted a report for providing compensation to the landowners upstream of the RCCs and such supply, wherein para 1 it is clearly stated the government has given administrative sanction, my lord, 10 crore, and stated in the last para that construction of dam across the river Umiao is at the taken up at the sloping portion of the river for possible avoidance of inundation of areas upstream of the dam on account of heavy rainfall during 2011. There has been backlash of water impounded against the dam. However, there has not been any report of inundation of cultivated lands after 2011. Now he says that PHE say that after 2011 there is no inundation. Now when we go to collector say 2013, my lord. This is without any report, my lord.
Yes.
My lord. According to me, my lord, this is without the basis of any record. This amount of misleading
Section 2
before
is?
this court. Now, this is the reply of the government, my lord. Now, they did not annex any materials to show that government did not, my lord, take a decision to acquire the land, not to acquire the land, my lord. They just make a submission, but I'll come to the citation.
The report is
later.
here.
My lord.
See this one, the village upstream last part, just read the para 5, Mr. Chandrasa.
Para 9, my
Page
lord.
12.
Oh.
Page 12, para 5.
Oh, yes. Para 5. My lord. The villages upstream of the dam raised their concern during the rainy season 2011 on flooding of cultivatable land. Though the construction of the dam Sunset River Omia was taken up at the sloping portion of the river Sunset, avoidance of inundation areas upstream of dam, but on account of the heavy rainfall, there was a backlash of water impounded against the dam. However, there has been no report of inundation of cultivable land after 2011. So this was the report.
Dated when the report?
My lord, the report is not, the date is not given here, my lord. It's only a forwarding. It's only a forwarding.
Forwarded in 2020.
Yes, my lord.
So it says that after 2011, there's been no inundation of the
My lord.
damaged cultivable lands not been inundated.
My lord, that is the report they have annexed in the 2020 letter. And whereas the deputy commissioner in his letter said there was no inundation after 2013.
No. After 2011, when was the report? No idea.
No idea. They did not disclose. They didn't give. My lord.
1 second. Where is the CNA? Yes. Come. See page para 4 also, very important.
My lord, construction of dam, my lord, across the river Umiao at Sansan jurisdiction, right, Sansan, was taken up following the permission accorded to Sansan. The dam initially meant to be 5 meters and Sansan was constructed at a height of 5.75 meter above bed level, approximately such and such, enough to create necessary head for water to gravity to the filtration plant. Height was reduced in according to, in order to avoid such and such. My lord, what happened exactly is that construction started, there was no survey, my lord. And after, my lord, the flow of the water is stopped, my lord. The water started inundating all the cultivation.
But you brought down the level.
My lord, to the highest level. Then this,
Okay.
my lord, and the river
Let's move on.
My lord.
Yes.
And thereafter, we filed the rejoinder. May I just show the rejoinder. Two rejoinders are there with regard to this. My lord can see a rejoinder filed by Nongindri CM.
Rejoinder.
My lord. Dated 30/7/2020. We have filed. Swear by Nongindri CM, one of the writ petitioner.
This is one by Sumaman Nongandri.
Sumaman Nongandri also filed, my lord.
What is this? Okay. Yes, what do you have to see in rejoinder?
Rejoinder Nongindri CM.
Yes?
Nongindri is swear by Nongindri CM. Worship.
There's no rejoinder dated?
Rejoinder dated
3/7/2020.
30/7/2020. 38/7. 38/7. 30.
It was only 30th July. 3/7/2020.
38 July, man. 38 July 2000.
30 or 3rd July?
38, 30, man. 38 July 2020.
One rejoinder here, 3rd July. And another rejoinder was 3rd July.
My lord, same day, my lord. One is swear by Sumaman Nongandri, writ petitioner.
And third rejoinder, 3rd July. How many rejoinders you filed?
Two rejoinders we filed
rejoinders here.
in response to the state respondent affidavit. May I just show me?
Where's the rejoinder then?
Madam, may I just
30th July is not here. Third. Just see the thing. Where's the 30th July?
Madam, may I just
kindly see.
May I just assist, madam. Madam, this one.
30th July is there?
Yes. My lord.
3rd July or 30th July?
My lord, it is written 3rd July, madam. I think my record is wrong, madam. 3rd July, madam. I'm sorry, madam. I stand corrected, madam. In my file, it's written 30, madam. Madam. Now, they denied everything. May I just come to the, my lord, the compromise agreement, page number 15, on the instruction of the government, madam. They drafted, they told them to draft and bring the thing.
Yes.
But this was 2019 December. Now,
1 second. Rejoinder.
Effort was made to compromise among themselves. My lord. And page number 117, terms and conditions are there, my lord. It says, my lord, second party thereby agreed that shall pay the compensation as per the all rates. So they agree for all rates. In reply thereto, they will withdraw the condition number 3, they will withdraw the repetition, pending repetition, the present repetition. That was the agreement. But the government never signed this agreement. The rest of the...
by you?
My lord.
Prepared by whom is compromise?
Prepared by the parties, my lord. By the parties.
That means it has no meaning.
My lord. Yes.
Agreement
And thereafter, my lord.
Never executed. Okay.
Yes, never executed.
Then?
And then, my lord, page number 14, my lord.
Yes.
Since it was never materialized, the petitioner has put up this representation letter to the that withdrawing that one, since it is not materialized.
No meaning of this.
Now the
withdrawal of compromise offer.
Yes.
Right.
Now, my lord, another rejoinder lordship has seen first, that is swear by Sumaman Nongandri. The front side, my lord. The front side.
Yes.
It is the same date, my lord. Sumaman Nongandri.
Yes.
My lord. My lord. Para 5 of her reply is a lengthy one. She has denied this, my lord.
Yes.
My lord. Collector, filed by collector, Mona Lisa Laking, my lord. This way by Mona Lisa Laking.
That is respondent's number?
Number 13.
Okay.
Collector.
Yes.
My lord.
Yes.
In para 3, my lord, she has admitted all the earlier assessment. My lord, she did not deny. Now, para...
no comments.
My lord.
No comments doesn't mean denial.
My lord, the law, the pleading is very clear.
We can't stretch
My
some,
lord,
yes.
the law is very clear, my lord, if they don't deny amount admission. And it will come to the para 4, my lord.
It's a writ proceeding, yes. It's not a...
Para
yes.
4, my lord.
Yes.
My lord. Statement made in para 6 of the writ petition, where it is clearly mentioned that the writ petitioner were being clearly informed by the PIO that respondent department has not invoked the provision of land acquisition sunset or sunset 2013, and also made it clear that no land acquisition process was initiated by the respondent authority, and as such the claim of the petitioner is liable to be rejected on the ground that land of the petitioner are not yet to be acquired by the government, state government, and moreover there is no approval from the government to acquire the land for the said purpose, hence the question of land being acquired the sunset does not arise. Now this, she has filed the affidavit after sanctioning. She has received all the amount, and yet she filed this status statement. Now may I come to the next para 6. Well, now this is the without in place of record. Now, statement made in para 18 of the writ petition is hereby denied. However, the deponent begged to submit that the initiation for construction of the Watangai RCC dam started around such for providing pure water and sensitivity. However, it is stated that there was no initiation to acquire the land as per the Land Acquisition Act. It is also back to state that during the years and such, some portion of the cultivated land areas were contiguous to the Watangai dam were submerged due to heavy rainfall, as a result of which damages were goes to the petty fields, cultivated lands of the landowner's petitioner. Well, so the Deputy Commissioner is made an assessment on damages, goes to the affected landowners amounting to rupees such, and accordingly estimated amount was approved and sanctioned by the government, and thereafter PHE has remitted the amount to the my lord, for compensation of for payment of compensation to the affected landowners. But there is no record of assessment of the damages.
So this is what I feel
it is absolutely assessment was for the compensation under the all act. Now she is trying to downplay, and it is a damages. Well, it's without any records. In our second part, it is stated that the alleged affected persons are not suffering as their lands had not been submerged after 2013. Now, PHE said that after 2011, there was no submersion. Here the collector said after 2013, no submersion.
Okay.
And
yes.
the last para 7, paragraph 7, it says that statement made by part 32-33 are hereby denied. However, it is stated that respondent deponent in consultation with the PHE department made a new assessment, as per the new act on its own initiative, but there was no approval for initiation of land acquisition process from the government till date. However, it is stated that the proposed lands which contemplated to be acquired are still under the possession of the land owner's petitioner, and they have been continuous cultivating their lands till date. Hence, payment of compensation as per the act does not arise. So that is the thing, my lord. Now the entire area is submerged, my lord. I don't know how it says that the cultivation is still going.
That is why, Mr. Chariso, the more you argue, the more the thing that emerges is that it's the writ court can't go into all this.
But my lord,
firstly is the chain of the sequence of events with regard to the factum of acquisition. That is one part. That's not clear. It has not culminated in any decisive, that yes, there's an actionable claim on your part. You have cause of action. You're not saying that if land has been taken by law, you have to be compensated. You cannot be taken just like that. Now, only thing is that now after, as you're proceeding the arguments, I think that fine, with that assessment, PH even has kept the amount with DC. That is a different matter altogether. There's no notification even.
Yes.
There's no notifications under what act's been done. Nothing has been done. How the money was kept with the collector also, that defeats any kind of, answer. How? It's a contrived. That means that, I'm sorry to say, this smacks of collusion from the beginning. This case with regard to collusion of the department PHE, whoever was in charge that time, and using poor landowners, colluding, enticing them to make this thing, maybe the donation agreement was made, enticing them, then depositing the amount. That is this is in fact it's a cause for inquiry.
Yes,
I think that at that point of time, who was the PhD engineer in charge?
My lord.
Now, why did he lead these people up the, he totally misled your petitioners.
Exactly. Lordship, correct.
Now, you see,
It
how
requires
is
for
they
inquiry
misled?
also.
Now, if land was really taken, there's a proper process.
Yes.
They should have come up with definite proposal that this amount be submerged, put up a collector, ask them to assess the land.
Yes.
Not at your own initiative, go and deposit the money,
Yes.
assess 6 crores, then go and then make assessment 78 crores again.
Right.
Now, who was going to gain from this?
Exactly.
As the case always is, poor people,
Yes.
the land might have been submerged, might have been taken away. Who's to gain?
My lord, I really feel sorry when I see the parties.
Exactly, because when you go through the facts now, and as you argue more and more, beautiful facts are coming, these people made to sign some agreement maybe. So they've been like a shuttlecock. They've been played around.
And they suffer a lot, my lord.
They have suffered
The
land's taken 2007, 2006.
My lord.
So now we are sitting in
2023.
2023,
my lord.
Very unfortunate.
I really feel sad. 2 of them already passed away who initiated this.
That is the thing. Now, whatever it is, if they are taken away, cultivable or not, if it's their land, they should be given compensation.
Exactly.
There's different grades for grading: cultivable land, non-cultivable land, waste land. So that's the thing.
My lord. And Lordship has correctly pointed out that this deserves proper inquiry also.
The thing is that how did they, for so many years, just went on like this?
My lord.
Nothing near here.
Nothing, my lord. And most of the petitioners are 75, 84 years old, 80. I really feel sad, my lord. This deserves. And with due respect, my lord, the assertion of the collector that it is a damages, no record.
No,
there is no record.
That is this a woman here, neither here nor there. Also.
My lord.
You see, nothing concrete is there. It's just that it's been played around.
They play around. One day they got for compromise.
So equations change, the different affidavit comes. Before it was a different equation.
Yes.
Some estimate, some preaching given. So who was anyway? Yes, please continue. But that's only the observation of the court, not to be taken seriously. But
yes,
the only thing is that these petitioners, if they
Lordship has exactly expressed the real concern. In the last occasion when the matter was taken up, my lord, may I apprise, we will argue before Justice Moria, my lord. The learned GA admitted that we offer compensation this amount, but petitioners are refused to come and collect this amount. He never said that it is the damages. Then thereafter, my lord, the situation changed now.
No, you see, that is even the amount deposited, I doubt if they ever get it also. If the bond even was released to them. Anyway, yes.
Now, thereafter, my lord, the affidavit filed, the additional affidavit filed by the party, my lord. Here, my lord, that affidavit filed by BHG, they never say it is a damages.
We're not going there.
Yes, and DC say it is
damages.
Yeah, my lord. And now the additional affidavit filed by the respondent BHG, dated 14 March 2023.
In March?
14 March 2023. 22, I'm sorry, 22.
Yes.
Well, para 3 onwards, my lord. Para 2-3 onwards. And here, para 3, continue the running page number 3.
This is the additional affidavit.
Additional affidavit. Now, here for the first time, he said it is a damages. Running page number 5. And in the middle, may I read out, my lord?
Of respondent number?
Respondent number 7 to 12, my lord. He filed on behalf of 7 to 12. He represented the department, my lord.
Yes.
And here in the middle of the page number 5, my lord. After the
very unfortunate, yes.
Decided not to initiate any land acquisition process for the project, my lord. There is no decision, my lord, placed on record that government will not take the land, my lord. Take the land, my lord. This affidavit was filed by the respondent who had lordship insists that they should produce the relevant record. Instead of bringing relevant records, he filed this affidavit. And the minutes, my lord, page number 18, adopted by the Chief Secretary then, my lord. Here everything is very clear, my lord. In that thing is, my lord, narrowed down and clearly reflected. With lordship permission, may I read, my lord?
Yes.
My lord. It says, minutes of meeting taken by the Chief Secretary to Government of Meghalaya held on 29 May 2019 at Sunset, my lord. Meeting was convened to discuss the issues relating to the legal notice, advocate on behalf of the petitioners and such, Sri Sumaman Nongprin versus State of Meghalaya and others for deliberate in order to delay in payment of suitable compensation despite illegally taking over the land, constructing a RCC dam of organizers and such. The meeting was chaired by the Chief Secretary to the Government of Meghalaya. With permission from the chair, the Chief Engineer PHE briefed the members as indicated below. The Watangai Combined Water Supply Scheme was accorded administrative approval Rs 10 crores, my lord. The scheme is intended to gather drinking water supply to 21 villages inhabitants under the arrangement Sunset inhabitants under Sunset, my lord. Among other components, the scheme envisaged construction of a small RCC wire across the river Sunset, my lord. Now, water from the small RCC wire is to be drawn by gravitational flow to the slow sand filtration plant, where after treated water is to be pumped to the main reservoirs located at Sunset and Liling Court Sunset for supply water Sunset, my lord. The scheme has been physically completed and commissioned during the year 2015, my lord. In the next year, we filed a writ petition, my lord. Thereafter, all the villages are supplied with potable water supply regularly. The execution of the scheme was carried out based on the authorization by the headman and Sunset, my lord. In March 2018, the administrative approved for payment of land compensation, my lord, it is very clear, was accorded rupees such only white lander number 29 March 2018. And later, September 2018, administrative approval for payment of rupees but the balance, my lord, only as accorded by the later and subsequently deposit with the Deputy Commissioner Iskasiyas. The Deputy Commissioner Revenue Iskasiyas Shillong, however, revised value of land compensation to rupees such. Well, the chairman asked the Deputy Commissioner Iskasiyas to verify how the compensation amount increased so much. It's a valid question, madam. The Advocate General of the Government of Meghalaya opined that the enunciation of the land was for a short period of sunset, but he was not supposed to carry that brief, but he was a chief engineer was there, madam. No records available to prove that inundation occur every year. Furthermore, the cause of inundation could either be due to construction of the dam, sunset, or due to rainfall. Record was not maintained. No notification for acquiring this land was issued. If private land is inundated on a regular basis for public service, then only acquisition to be initiated and compensation paid accordingly. My lord. Decision of the meeting, my lord. Deputy Commissioner shall verify the matter in details and submit the information to the Chief Principal Secretary to the PHE Department as to how the new assessment has been made. Number two, my lord, reassess the whole process of acquiring of land only if the land is required for keeping the scheme functional. My lord, the meeting, my lord. This was the decision, and collector has given his reply, my lord. My lord, page number 21 was this minute was submitted to the collector for his verification report, page number 21. And thereafter, collector has given his report, page number 22. And the reason for inflation, he has highlighted the differences between the two calculation system. It says that with reference to subjects cited above, I am to inform you that new assessment has been made as per the 2013 with the intimation and consent from the requiring department. Copy enclosed. If the all probable cause statement and the new statement were examined, copy census, my lord. The rate of land as per square meter in the all probable cause is fixed as per the valuation rate fixed by the Deputy Commissioner with census 1894, whereas the new probable cause census and such, my lord. Yes.
It doesn't answer anything. Also.
Wait a minute. So he was clarified this one, and thereafter, my lord, there was no step was taken further. Therefore, lordship, seeing this situation, lordship has earlier passed an order. We just recollect lordship order. Lordship has passed order earlier. Yes. Lordship, can you see lordship order date, my lord, 21 June 2022, where lordship directed for inquiry. Two direction was given by my lord.
Date 21?
June 2022.
Okay.
After reading this affidavit, my lord,
yes.
that time lordship was yet to go through the entire government's pleading, but after reading the additional affidavit, lordship passed his order. And para 6, my lord, to save lordship time, para 6, my lord, may I read, in this backdrop and in view of the rival contention of the parties, this court cannot come to any definite conclusion. In this context, the learned counsel for the petitioner has placed the reliance on the decision of the such, my lord, wherein, with regard to the factum of the actual possession of the land, a spot inspection directed such. In this instant case, in important matter, this court is also faced with a similar situation, inasmuch as, leaving aside the compensation aspect, my lord, the fact as to whether the said land is required for the purpose of the scheme, or whether the same has been taken over by the state government respondent is not clear, hence to be ascertained. Accordingly, is important number 1. The respondent number 4, that is the Commissioner and Secretary of Government of Meghalaya PHG, is to file a report as to whether the said agricultural land certificate is still required for construction of the water supply So this direction they never filed it. Second was, my lord, directed to learned district judge. District judge has placed his report, my lord, and saying that it is a fact report, my lord, according to me. But there was a clear finding, my lord, in his report also, that both sides of the river.
Even the landowners are not they fight at this. Anyway, we will not.
My lord, he said both sides of the river, the dam, the lands are there, occupied by the PHG. That is his finding. Though he should be more elaborate, I do admit, he should be more elaborate in clarity, so as to, my lord, enable this court to.
That report has not been submitted by the PHG till now.
Not submitted, my lord. Not submitted. They know the consequences, my lord. If they submit it, is not required.
Yes.
My lord. They did not submit till today. That one also.
That's it. Now.
But if the lordship allow me to place the judgments,
yes,
the number of judgments I have, if the lordship permits.
Yes.
My lord, yes. First, my lord, 2003, 13 volume 1. SCC page number, my lord, page number 353. My lord. May I not read all the paragraphs? But this is with regard to the rights of the landowner, that government cannot take away without due process of law. A settled position.
See, but the thing is, what is court's concerned, but whatever's happened now since how many years, it has been taken away. You cannot be deprived like this. That's all.
That is
and even then, the sad part is that it'll take a few more years for, if you. So we don't know.
My lord, if lordship do not intervene, it will go on like this.
Due to no fault of yours, due to the fault of the official respondents only. That's the thing.
My lord. And
playing cat and mouse.
My lord.
Yes.
My lord. In other decisions, like the right one, may not place, my lord. Other decisions.
Para of this one, which one?
Para may just indicate, my lord. Para 10, para 9, 10, 11, 12, 17, 21, and 23.
10, 9, 10, 11,
12, 17.
Okay.
21. I have indicated in my note.
Okay. Yes.
My lord. Other also, my lord, 2010, 11 is there. My lord. We'll just read together with that. 2010, 11.
Yes.
My lord. And next one in my lord, 2013, 14 also. There also, my lord, land was taken over. No acquisition for land, procedure was followed. Land was developed. Therefore, Supreme Court directed for acquisition, payment of compensation. My lord.
Which one?
My lord, 2013, volume 14.
Okay.
My lord. And the next one, my lord, with regard to pleading, 2005, volume 7. It clearly says, my lord, that the government cannot make a plea, they hold their own records. My that lordship is very much clear, the law point. Pleading in evidence, my lord, I will not take. Pleading will be supported by facts, my lord. And other one is, my lord, pleading supported by facts, 2010, volume 10. My lord, 1978, volume 1 is a renowned case, lordship is aware. Cannot be supplemented by reasons, my lord. Now, propounded a new case, my lord. Now, they said earlier, my lord, they take the same plea that there was no proposal. Therefore, this Honourable Court directed the Chief Secretary to take a decision. According to me, he has taken a decision. Once he has taken a decision, my lord, government cannot say that there is no proposal. We are not taking land, my lord. They cannot blow hot and cold, my lord. And inconsistent affidavit is number 3, judgment number 3, my lord.
Yes.
My lord. Admission, my lord, para page number 4. Admission also there, I have cited 2-3 decisions, my lord. And not come, my lord. Filing false affidavit also there, my lord. Now, the disputed question of facts, this which appears to be relevant, lordship has pointed out. It started from disputed question of facts. I have relied, my lord, 5 judgments are there. May I just place a few decisions, my lord? I may not take.
Yes, please, please.
1970 volume 1 SCC, relevant para I have indicated. 1970 volume 1 SCC, at the bottom, lordship, can you see? Page number 4. And relevant para I have indicated, to save lordship time, I will not go through. Para 13. And
century spinning wheels.
My lord.
Yes.
Another is 2004 volume 3, my lord. Is a para 16 and 51.
Let's see century spinning wheels. 1970.
My lord, 1970, lordship is looking. Yes. 70 volume 1. Yes. Para 13, my lord. It says the Kokali appearing on behalf of the respondent municipality urged that the petition filed by the company apparently raised a question of facts, which in the view of the High Court could not appropriately be tried in exercise of those extraordinary jurisdiction under Article 226. Yes. But the High Court has not said so. So this is one. Another one was my 2009 volume 8, also there, my lord. And
2009 volume 8.
Yes, my lord. And another Supreme Court decision 2000, my lord.
That is para
38 and 39. Whatever I give, keeps away. With regard to, my lord, to serving the disputed question of facts, my lord. There's one judgment I've relied on this. I'll just show para 3, my lord. Supreme Court order 2004. It says in order to consider this submission, one has to look at the averments made in the petition. Para 3.
Yes.
Averment made in the petition and reply to those averments in para such and such. So I'm trying to bring home that, my lord, a fact statement cannot be amount to denial, and well, if there is no denial, there is no disputed question of facts, my lord. And
yes,
with regard to, my lord, I have done some the research without permission. Most of the cases I came across, my lord, in the nature of this case, submersion, court hardly, my lord, court hardly 2-3 decisions are there. Court hardly relegate the parties to the civil courts, knowing that, my lord, civil court how the matter would be asserting. So
when did this court express going to civil court?
No, I'm not saying my lordship expressed. No, I'm trying to say.
Why are you saying that? That relegating the party civil court? When did this court ever express its
not express
any observe that we're sending to civil court?
Not express, but that is the attempt made by my friend, rendered respondent. They disputed question of a court to civil court. So I want to apprise my lord, my lord, that some of the cases that we come across, including Supreme Court order, High Court always directed the competent authority to conduct a fresh survey and give a report and give a, my lord, and proceed for compensation. Those decisions, my lord, I may place those.
Yes.
This may start from the, my lord, just from the High Court, may I start? 2015 decision, my lord. This is Karnataka High Court. More or less similar situation arises here in this case also. My lord, lordship, kindly start from para 3, 4, 5, my lord. The land was under submersion. Party came to the court. The government lawyer disputed that there is no submersion. And finally, my lord, may I start from the para 5, my lord.
Yes, I'm reading para 5.
My lord.
Yes.
The records clearly disclose that the petitioner gave a representation to the authorities under the
we have already done that survey, which then came to 0. regarding to find out whether any of the land was submerged from the additional district judge, but he didn't, it's neither here nor there. So anyway, any other judgment?
My lord, other judgment also, my lord. Then the same judgment, the flag number 2, Lordship, may I see?
Yes.
Flag number 2.
Okay.
My lord. This is Mumbai High Court. This is more or less similar case, case of submersion because of the construction of dam. My lord. There was a direction was given for survey and acquisition if submersion is there.
Yes.
And the next one, flag number 3, Lordship, can you see? Here was Andhra Pradesh High Court, more or less a similar nature. Submersion because of construction of dam. Direction was given, my lord. Para 7 onwards. Para 7 onwards. And another Supreme Court judgment.
It's here, the flag is here? No.
My lord?
It's together with here, Supreme Court judgment?
Supreme Court, my lord, separately, if Lordship allow me.
Okay.
May take to relevant para, my lord, 15 and 16. My lord. Here, though it regards to, my lord, interest, effect of interest under the Land Acquisition Act. However, Supreme Court passed an order.
Yes, yes.
May start from, my lord,
15 and 16.
Para 15 and 16.
Yes, I got it.
My lord, may read that in the instant case, the date of taking of the position submergence is disputed, and there is no categorical finding recorded that area in question came under submergence with the effect from 1991 and was not as a matter of fact in possession of the appellant. Certain documentary evidence has been pointed out indicating the land was in cultivating possession of the appellant. It is also not clear as to how much period of a year the rain in question remained in submergence. Certain documents have been filed by the appellant in this court in the form of correspondence showing that certain survey numbers in various villages came under submergence, which was required to be inquired. The question, which were those survey numbers that came under submergence, has to be examined by the collector. The claim of damages would depend upon the fact of whether the land has come under the submergence in the year 1991, for which adequate direction have to be issued by the collector, High Court to the collector. In these circumstances, we direct the collector shall examine whether the area had come under submergence and shall determine the quantum of damages to be paid from 1991 till the date of notification under Section 4. In case the area has come under submergence, then the appellant shall be entitled to the interest under from the date of notification under Section 4 till also award. Interest under at the most can follow from the date of notification under Section 4. Here, in this case also, the land was under submergence. They never acquired it. Therefore, later on, they realized, then they issue Section 4 notification.
What happened here in your case is that it was prior to 2007 that OLAC was there. Once the dam was there, they should have, if there was really an intention on the part to be fair to the writ petitioners, the ratified land issued Section 4 notification. You know, whatever, then they would have gone in the normal process. But it was never done. It was done total go by to all the set procedures.
Right. That is the problem.
And then after that, proposal submitted, now denied.
Correct. Therefore,
now whether the people, what land submerged was not at this stage. Anyway, yes.
In view of that delay on the part of the department also, this petition were ready for compromise also, a give and take to take a meter part, but that was not materialized also.
Right.
Now, as a last judgment, my lord, since with regard to other project, the guidelines are there with regard to Valley project, where my lord, the Andhra Pradesh also Supreme Court has referred those guidelines with regard how to ascertain to what extent under submersion, my lord. It is also there.
Yes, Mr. Sasrika, what do you have to say? You've heard the lengthy submissions of senior counsel. Not much.
5 minutes.
Yes, you have half an hour. The respondents. Other hearings, Any hearing ready?
Number 19 will come after some time, Lordship.
19 ready?
19.
Number
19.
Yes.
Just take time, Lordship, because maybe after 2 weeks, I just need to produce some judgment, Your Lordship, because similar security case was from this court, so I just need to get it order, Lordship.
19 after 2 weeks. Yes.
Lordship.
The request of the petitioner.
Much blessed, Lordship.
Your Lordship, in number 18, Your Lordship, nothing remains in the matter anymore, Your Lordship, because the work order that was issued, also the term concludes today.
But it got extended, Your Lordship. It got extended, Lordship, the contract.
It's extended?
Yes, Your
I'll
Lordship.
have to seek instructions, Your Lordship. In
Yes,
that
take
case.
number 18, take down. Take down MS that Eno Country Learned Council and the GA submits that nothing survives the matter, as much as the work order that has been issued. It expires today, the 31st of March. However, Mr. Lasung Lawyer, on behalf of the petitioners, submits that he has been informed that his work order has since been extended.
Your Lordship, my friend is here for the private response.
And for respondent number 6, as on date, Your Lordship, we haven't received any
extension.
communication to that effect.
Anyway, you verify. But
Your Lordship.
yes, MS councils to verify. Parties will. Today they were out to verify the statement made by the petitioner. And this is matter after 1 week.
Yes, Your Lordship. Much obliged, Your Lordship.
Yes.
Your Lordship, item number 17, Your Lordship, Gurdeep Singh. Lordship, my senior was ready, but I need some more accommodation because he left because he had some meeting.
17?
17, Gurdeep Singh, yes.
I'm appearing on behalf of respondent number 1, my lord.
Where's Dr. Mosque on station?
He had to leave the premises due to some personal difficulty, my lord.
Okay, after 1 week.
Okay. See, your Lordship, getting the 5th, Your Lordship.
1 week? Yes.
10. I did 10 total. 10.
Ten is a short matter, Your Lordship.
Then we do it. Yes, you wait some time. We just finish. Yes, you're ready with 10, right?
Lordship, Mr. Paul is still on legs, Lordship.
Where is on legs?
Item column 3, Lordship.
We'll wait then. Let's finish the matter first. Yes. Yes, please continue. Oh, you're finished, Mr.
My
Chancellor.
lord, before the GS submits,
Yes.
I just place some more decisions.
More decisions?
My lord, some more decisions.
I'm sorry. I thought that's why I took up the other matters. I thought that.
My lord, I'm sorry, man. Lordship has given me time.
Yes. Yes.
My lord, with regard to file noting or decision of the government, my lord, the law on this, my lord, whether the file noting and communication given to the party is binding to both the parties or not, my lord. With regard to that judgment, may I please, it is important, my lord. First judgment, may I please, AIR is a 5-bench judgment. AIR
It's
19.
not in the list.
But it is in the list.
Isn't the list given?
It is in the list.
Fine.
It's in the list. The last page, page number 5, Lordship can see.
Okay, yes.
My
What
lord.
does 863 say?
63 says, my lord, that once, my lord, the noting has been taken and is communicated to the parties, it is binding to both the parties. Both the parties.
Okay.
Now, I'm trying to bring home that the pursuant to division bench direction, Chief Secretary has taken decisions and communicated to me. And that decision is binding to both the parties. Now, government cannot say that there is no decision to take the land. For proceeding, they may take, my lord, but they cannot say that they were not taking their land. Similar, my lord, 1993, volume 2 also, my lord, 2003 also, 2009,
Yes.
19 volume 2. These are all, my lord, may I read or Lordship can?
Let's see.
Oh, yes.
Para?
Lordship is looking to which?
1993.
Oh, 1993.
SCC.
Para 25, my lord. 1993. Para 25.
Para 25? Nasim Banu? Oh, page 84. Flag page. No, they flagged the wrong page.
Flag, my lord.
Wondering.
Page 31, my lord.
Page?
Page 31.
Page 84 or page?
My lord, this
page number. You've seen your page
number, my lord. I'm sorry, page number 84.
84.
Well, 84, my lord. It's 84, I'm sorry.
But there's no 84, it's 80.
My lord.
It's 82.
84 is page number 84 is there. 1993.
Yes. Yes.
Para 25 it says. Para 25, may I come to para 25?
Page 44 was open. Para 25. Flag 44. Flag 41. Para 25.
Para 25.
Yeah.
Well. May I read from the above material, it is clear that there was no final decision at any time to denotify the said land. A tentative decision was no doubt taken in February and such, but before it could be implemented, the government took it necessary to ascertain in views of the housing board and to find out as to what the board had done upon the land, what structure it had raised and what amount it had been spent, so that the board could be compensated while delivering the possession back to the housing society. Before this could be done, there has been a change in the government and the said tentative decision was reversed. In this view of the matter, it is not necessary for us to go through the question whether there was a communication of the decision of the government to the petitioner. The communication must be our final decision and not of a provisional or tentative decision. I'm trying to bring home that Chief Secretary communication is not a tentative decision. It was a final decision given to me.
It's not a final decision.
My lord, I tried to
It's not a final decision. It doesn't decide
in this
anything.
case, my lord.
This one, see what this judgment goes against you. There's a change government that said that they would reverse. It's reverse, tentative decision.
Yes.
There's no final decision. This is a matter necessary for us to go to question whether there's a communication of decision to government. The communication must be final and not provisional tentative.
My lord, in this case.
So,
in this case.
It's a final decision, you say?
My lord. In this decision. In this decision, my lord.
Yes. Okay. There's no decision anywhere.
But I'll come.
See, the thing is that the fact remains, Mr. Changreso, if land has been taken, you'll get compensation. Forget about any decisions for proceedings that earlier on. That's all. Forget about that. Whatever happens, happen. If your land has been taken, it is your right to be compensated. That's all.
That is what I'm begging for.
And the duty of the councils and the court is to see that this is done expeditiously without any further harassment to the people. That's all.
Exactly.
Amount doesn't matter.
Amount doesn't matter.
But the way the thing has gone on has gone totally in a tangent from what a normal procedure should do.
My lord. No. Exactly.
Because there are too many, can make out from the record, there was a lot of...
Right. My lord.
Yes.
My lord. Only my 2009 volume 15 may say, cite. 2009 volume 15 SCC. Relevant para 20, 21, 45, 52 and 53, my lord. I've indicated there also, my lord. Just point of one relevant para.
Yes.
My lord, I may just take it to save lordship time. Para 52. Para 52. May I read, my lord. As a result of the above discussion, we hold that the nothing recorded in the official files by the officers of the government at different levels, and even the minister, do not become decision of the government unless Well, the same is sanctified and acted upon by issuing an order in the name of the President or Governor, as the case may be, authenticated in the manner provided under Article such and such, and is communicated to the affected person. The noting or a decision recording the file do not confer any right or adversely affect the right of any person, and the same has neither been challenged in the court nor has made a basis for any relief. Even if the competent authority records a noting in the file which indicates that some decision has been taken by the authority concerned, the
It
same
goes against
can
you
always.
also.
But I'll come. If we read para 30 or 53 also, my lord.
Para?
53 also. It is in my favor, my lord.
52.
53 on 53. The next para also, my lord. In 53, my lord, it is in the middle. The noting has never translated into an order, nor was the same published in the official gazette in the form of a notification. It was not even communicated to the appellants or the DD. But the reason for this, my lord. So the other judgment also, my lord, it is very clear.
So out here there were notifications issued. The decision whether the decision to withdraw to denotify was communicated or not. Those are this concerns that. Suppose a notification, okay, to denotify, the decision was taken, but it's only in file noting. So those are the things. I don't think we're not really bothered about that. We have one bigger picture.
Yeah, the bottom of the case, my lord, whether the land has been.
The core of the case. Yes.
The core of the case. So my hope
yes,
is,
Mr. Zarika. We'll hear you in reply. If you won't have any replies, yes.
May I please?
All your other lawyers have deserted you. Your assistants. Or you're alone.
They have gone out. Anyway, my lord, so that is writ petition, page number 30, prayer portion.
30? Prayer portion.
Oh my God, writ petition.
Yes.
Shall I read my lord? In the above premises, it is humbly prayed that the Honorable Court may please to issue notice following upon the respondent as to why an appropriate redirection should not be issued to direct the respondent state to immediately pay suitable compensation as per the provision
yes.
of right to fair compensation and transparency, Land Acquisition, Rehabilitation and Resettlement Act 2013, my lord. Now my question is coming, my lord. Under what basis that can be claimed, my lord? And what circumstances the right to compensation and transparency applied, my lord, in section 2?
I got it. 2013.
Application of the Act.
Number section 2.
Yes, my lord. Section 2, my lord. Why this application applied and how it is applied and what circumstances it will be applied. Shall I read out, my lord?
Yes, I please the act. Yes, I read.
Yes. The provision of this act relating to Land Acquisition, Compensation, Rehabilitation Act and Resettlement shall apply when the appropriate government acquire land for it, its own use, hold and control, including for public sector undertaking and for public purposes, and shall include the following purposes, namely, my lord. Number 1, for strategic purposes relating to naval, military, air force and armed forces of the Union, including central paramilitary forces or any work vital to national security or defense of India or state police, safety of the police, or for infrastructure project, which include the following: all activities or items listed in the notification of the Government of India in the Department of Economic Affairs and Infrastructure section number such and such dated 17 March 2012.
Now, what do you want to show?
I mean to say here, my lord, I will not go for details. This law applied when the government required the land for their own use or any undertaking government or cooperation or other things, their own use or the public purposes. Then the question of this law applied, my lord.
It's for public purpose. What is applied?
Here, my lord, I am coming to that point. I am coming to the then. In that case, it is required. Then next, what to do?
Yes.
Now come section 11, my lord.
Exactly. That's what the courts observe all along,
Yes.
Mr.
Yes,
Pajarika. I said that the entire sequence of events in this case
Yes,
is divorced of any procedure.
Yes.
It's just
here also there is no notification. After that, the survey of land will come. Then social assessment will come. Then the question of acquisition is coming into play.
exactly. I'm in total agreement. Court total agreement with you. Total agreement. That's why this courts expressed earlier on. Mr. Charni, that is why these people have been given a raw deal. Yes. Yes. Next point.
Next point, my lord, what I have filed my affidavit in.
That's it.
That's all. I rely on that. And moreover, another important is that your lordship has directed for inquiry.
Yes.
Into this inquiry report also taken into consideration.
Nice submissions, short and sweet.
Much obliged.
Yes. Hearing concluded, Ms.
May I just pray?
On this.
May I just pray that if the argument is persuaded to my lord, then lordship may direct the government to acquire the land within a time frame, since they have deposited few amount also. In case if lordship is not persuaded, twofold, my lord, twofold prayer.
Yeah.
It is a fit case where lordship may direct the competent authority, the legislating judge, or whichever authority lordship decide, to conduct a fresh inquiry and come up with a report and take appropriate decisions, my lord. Otherwise, my lord, this is...
They are not made up of mind at all. So let me examine it and see which are the avenues available.
Okay.
So that we can meet the ends of justice like this. Yes. Come next matter.
Much
10.
Much of you.
The conducting process is still on next.
Start.
Matter.
Yes. You ready?
Lordship, I'm not in a position, Lordship.
You're not in a position?
Yes, Lordship. Let's take a policy handling.
When do you want it done? I would love
After 2 weeks.
Council for the fish submits that due to unavailability of the senior army council, matter to be adjourned for today. Yes, but this is matter and so on, sir. Take your chance. Next day when it comes up, you do it. Right? Thank you.